Good afternoon to everyone, and thank you all for coming to the public meeting of the United States Sentencing Commission. We welcome all of you, those who've come in person, and those of you who are watching us live stream worldwide. As always, we appreciate the significant public interest in federal sentencing issues. At the outset, I want to thank everyone who took the time to submit their comments, and especially the individuals and organizations who testified at our March hearing. I want to thank the members of Congress who submitted letters, particularly Senator Grassley and Senator Feinstein. And I'd also like to thank the Department of Justice, the Federal Public and Community Defenders, our advisory groups, and the many advocacy groups, law enforcement organizations, and of course individuals who submitted views. Public participation in the process is critical. Now, we are here today, all of us, including Judge Breyer, our vice chair, who is Oz-like attending via telephone. I always have a tendency in court when someone is attending via telephone, I stare at the boxes as if I'm looking at them, but he will be participating by phone since he was unable to travel to DC this month. So the first order of business is to adopt the January 9th, 2015 public meeting minutes. And is there a motion to do so? So moved. Is there a second?
Second.
All in favor?
Aye.
Aye.
Anyone, that's it, I hear him. Anyone opposed? The ayes carry it. The next item of business is the report of the chair, me. I'd first like to discuss the National Training Seminar. We are pleased to announce that the annual National Seminar on the Federal Sentencing Guidelines will be held in New Orleans, Louisiana on September 16th to the 18th, 2015. Conference details, including information on how to register to attend, will be posted on the website. And our fiscal year 2014 source book and the Commission's annual report are now available on the website as well. Next, I'd like to turn this over to the staff director, Ken Cohen, who has a
Thank you, Judge.
to announce. Okay.
I just wanted to bring to the attention of the public a few changes on our staff in important positions that you all often interact with. The first is that Pamela Montgomery recently retired after 30 years of distinguished federal service. She had been our longtime Director and Chief Counsel of the Office of Education and Sentencing Practices. Over her tenure, she helped train literally tens of thousands of judges, probation officers, and practitioners, and we are grateful for her service. Raquel Wilson is our acting Director of Education and Sentencing Practices. She's been with the Commission for the past 6 years as Deputy General Counsel. Also, Noah Bookbinder recently left the the Commission. He had been our Director of the Office of Legislative and Public Affairs for almost 2 years. He has left to become the Executive Director of Citizens for Responsibility and Ethics in Washington, and he was instrumental in helping us navigate the drugs and Drugs Minus 2 and retroactivity work that we did last amendment cycle. And so we will miss him as well. Kira Antel, who's worked in our Office of Legislative and Public Affairs office for 7 years, is now our acting Director of Office of Legislative and Public Affairs.
Thank you. Now I turn this over to Kathleen Grilly, our General Counsel, who will advise the Commission on the first possible vote.
Yes, Judge, thank you. The first amendment for your consideration this afternoon is a proposed amendment on technical matters. It's the technical amendment. This amendment makes certain technical changes to the guideline manual. First, it sets forth technical changes to reflect editorial reclassifications of certain sections in the United States Code. And to reflect those changes, changes are made to the commentary in 2C 1.8, 2H 2.1, and 2M 3.9, Application Note 5 to 5E 1.2, and Appendix A, the statutory index. Second, the amendment makes stylistic and technical changes to the commentary following Section 3D 1.5 to better reflect its purpose as concluding commentary to Part D of Chapter 3. And finally, this amendment makes clerical changes to the background commentary to 1B111 and 2B4.1, subsection E7 to 2D11, and application note 2 to 2H4.2. A motion to promulgate the technical amendment with an effective date of November 1st, 2015, and with technical and conforming amendment authority to staff is appropriate at this time.
So moved.
Is there a second? Second. Any discussion? All in favor? Aye.
Aye.
Any nays? The motion is adopted, and I also want to let the record reflect that at least 4 commissioners voted in favor of the motion. So the next possible vote.
Yes, Judge, the next vote is on the single sentence rule. It's a circuit conflict regarding the meaning of single sentence rule and its implications for career offender guideline and other guidelines that use predicate offenses. When the defendant's criminal history includes 2 or more prior sentences that meet specified criteria in the guidelines, those prior sentences are counted as a single sentence rather than separately. Generally, this rule operates to reduce the cumulative impact of the prior sentences on a defendant's criminal history score. Courts are now divided, however, over whether this single sentence rule also causes certain sentences that ordinarily would qualify as predicate offenses to be disqualified from serving as predicates. Specifically in 2010, in King versus United States, the Eighth Circuit held that when 2 or more prior sentences are counted as a single sentence, only one of the prior sentences qualifies as a predicate. In contrast, in 2014, in United States versus Williams, a panel of the Sixth Circuit considered and rejected King as nonsensical because it permitted the defendant to evade career offender status because he committed more crimes. In that case, because each of the sentences subsumed within the single sentence ordinarily would receive criminal history points, the panel held that the sentence that ordinarily would qualify as a career offender predicate was not disqualified by the single sentence rule. It remained eligible to serve as a career offender predicate. The proposed amendment generally follows the Sixth Circuit's approach in Williams. It amends the commentary to 4A1.2 to provide that for purposes of determining predicate offenses, a prior sentence included in a single sentence would be treated as if it received criminal history points if that prior sentence independently would have received criminal history points. It also provides examples to illustrate. Finally, 4A1.1 and 4A1.2 are revised stylistically so that sentences counted as a single sentence are referred to instead as sentences treated as a single sentence. A motion to promulgate the proposed amendment with an effective date of November 1st, 2015, and with technical and conforming amendment authority to staff is appropriate at this time.
Thank you. Is there a motion?
So moved.
Is there a second?
Second.
Is there any discussion? I wanted to make a comment about this. I've had some reservations about the single sentence amendment, which resolves a highly technical circuit conflict on how to count criminal history for purposes of the career offender guideline and other guidelines relying upon predicate offenses. At our hearing in March, however, stakeholders agreed that the issues come up very rarely. I remember sitting there and I asked everybody to testify, how often does this come up? And everyone says, rare, rare, rare. And the logic of the Sixth Circuit in the United States versus Williams is compelling. However, this circuit conflict highlights the bigger problem that the career offender guideline is only followed, given our most recent data, in about 25% of the cases as a result of departures and variances. 43% involve government-sponsored departures, and 29% are non-government-sponsored departures or variances. As part of our overall crime of violence report, we are looking at career offender cases to see if there's a better way to define predicates so that the higher sentences are triggered by appropriate predicate offenses. So did anyone else have anything they wanted to add to that? So a vote on the motion by saying aye. All in favor?
Aye.
Anyone opposed? The motion is adopted, and let the record reflect that at least 4 commissioners voted in favor of the motion. Now we move on.
The next amendment for your consideration is on jointly undertaken criminal activity. This proposed amendment would revise 1B1.3 to provide more guidance on the use of jointly undertaken criminal activity in determining relevant conduct under the guidelines. Specifically, it restructures the guideline and its commentary to set out more clearly the 3-step analysis the court applies in determining whether the defendant is accountable for acts of others in jointly undertaken criminal activity. The three-step test requires, first, that the court identify the scope of the jointly undertaken criminal activity. Second, determine whether the conduct of others in the jointly undertaken criminal activity was in furtherance of that criminal activity. And finally, determine whether the conduct of others was reasonably foreseeable in connection with the criminal activity. A motion to promulgate the proposed amendment with an effective date of November 1st, 2015, and with technical and conforming amendment authority to staff is appropriate at this time.
Thank you. Is there a motion?
So moved.
Second?
Second.
Any discussion? All in favor?
Aye.
Any opposed? The motion is adopted, and let the record reflect that at least 4 commissioners voted in favor of the motion. Inflationary adjustment. Ms. Smith.
Yes, Judge. The next proposed amendment for your consideration adjusts monetary tables in the guidelines to account for inflation. Specifically, the proposed amendment sets forth an approach for amending the 7 monetary tables in the guidelines to adjust for inflation based on changes to the Bureau of Labor Statistics Consumer Price Index and on different time frames, taking into consideration the year each monetary table was last amended. For each of the 7 tables, the proposed amendment adjusts the amounts in the monetary tables using a specified multiplier and following a specific rounding methodology that is laid out in the amendment. For the loss table in 2B11 and the tax table in 2T4.1, the proposed amendment adjusts for inflation since 2001. For the loss tables in 2B2.1 and 2B3.1 and the fine table at 5E1.2, the proposed amendment adjusts for inflation since 1989. For the antitrust table in 2R11, it adjusts since 2005. And finally, for the fine table at 8C2.4, it adjusts for inflation since 1991. Each of the tables shows the initial multiplier used to make the adjustments for inflation, and as an aid to the reader, the proposed amendment is set forth in a manner that indicates at each level of the monetary table the effective amount of the multiplier that results from the rounding methodology used. In addition, the proposed amendment includes conforming changes to other Chapter 2 guidelines that refer to the monetary tables. Finally, the proposed amendment also includes a special instruction for both 5E1.2 and 8C2.4, providing that for offenses committed prior to November 1st, 2015, the court should use the fine table that was set forth in the corresponding guideline that was in effect on November 1st, 2014, rather than the fine table as amended for inflation. A motion to promulgate the proposed amendment with an effective date of November 1st, 2015, and with technical and conforming amendment authority to staff is appropriate at this time.
Thank you. Is there a motion? A second?
Second.
Any discussion? I'd like to make these remarks. This amendment is a key example of the Commission's good government focus to ensure the guidelines in federal sentencing work well. Congress has generally mandated that agencies in the executive branch regularly adjust the civil monetary penalties they impose to account for inflation. The monetary values in the Chapter 2 guidelines have never been revised specifically to account for inflation. The vast majority of public comment supported adjusting the tables for inflation. We believe this amendment received widespread support because we all know that $1 today is worth less than it was in the past. As such, the Commission has adopted changes to all monetary tables, including fines, which will result in increased fines, and we have used the year each table was last substantively amended as the baseline from which to determine the inflationary rate. So a vote on the motion. All in favor?
Aye.
Aye.
Any nays? The motion is adopted, and let the record reflect that at least 4 commissioners voted in favor of the motion. Mitigating role. Thank you.
The next amendment for your consideration is a result of the Commission's study of the operation of the mitigating role guideline at 3B1.2. First, the proposed amendment addresses differences among the circuits about what determining the average participant under this guideline requires. The 7th and 9th circuits have concluded that the average participant means only those persons who actually participated in the criminal activity at issue in the defendant's case. so that the defendant's relative culpability is determined only by reference to his co-participants. In contrast, the First and Second Circuits have concluded that the average participant also includes typical offenders who commit similar crimes. Under this latter approach, courts will ordinarily consider the defendant's culpability relative to both his co-participants and to the typical offender. The proposed amendment generally adopts the approach of the Seventh and Ninth Circuits. Second, the proposed amendment provides a non-exhaustive list of factors for the court to consider in determining whether to apply the mitigating role adjustment, and if so, the amount of the adjustment. It provides, as an example, that a defendant who does not have a proprietary interest in the criminal activity and who is simply being paid to perform certain tasks should be considered for a mitigating role adjustment. Third, the proposed amendment provides that the fact that a defendant performs an essential or indispensable role in the criminal activity is not determinative. Such a defendant may receive a mitigating role adjustment if he or she is substantially less culpable than the average participant in the criminal activity. Fourth, the commentary to 3B 1.2 provides that certain individuals who perform limited functions in the criminal activity are not precluded from consideration for a mitigating role adjustment. The proposed amendment revises this language to state that such an individual may receive a mitigating role adjustment. A motion to promulgate the proposed amendment with an effective date of November 1st, 2015, and with technical and conforming amendment authority to staff is appropriate at this time.
Thank you. Is there a motion?
So moved.
Is there a second?
Second.
Is there any discussion? I have these remarks. This amendment is intended to provide additional guidance to judges when considering whether an offender should receive a mitigating role reduction to his or her sentence. Our review of data found that mitigating role was applied in only 7.6% of federal cases, and 3/4 of those were in drug offenses. The Commission never intended for mitigating role to apply so rarely or to focus so much on drug cases. We believe that this change will assist judges to make appropriate determinations in other offenses, including some fraud offenses. The amendment adds a non-exhaustive list of factors that judges should consider in determining whether an offender is a minor or minimal participant, and it makes clear that the focus should rest on crucial questions that go to the offender's culpability. These questions include whether the offender was aware of the scope of the offense, had a proprietary interest in the outcome of the offense, or was involved in the planning or organizing of the offense. We hope this amendment will encourage courts to consider mitigating role in appropriate cases, and that judges will find these factors helpful in their sentencing determinations, particularly in fraud cases where a minor participant with no proprietary stake in the criminal activity can sometimes face a harsh sentence disproportionate with his individual role. Vote for all those voting in favor of the motion.
Aye.
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 Any nays? All in, the vote carries, and the record reflects that at least 4 commissioners voted in favor of the motion. Hydrocodone.
This proposed amendment addresses the new statutory penalty structure for offenses involving hydrocodone and hydrocodone combination products in light of 2 recent administrative actions that had the effect of moving all offenses involving hydrocodone, whether in combination or standing alone, to Schedule 3. First, in October 2013, the Food and Drug Administration approved a single-entity hydrocodone product, brand name Zohydro, the first such product to be approved for the United States market. Such as a product is a Schedule II controlled substance. Other single-entity hydrocodone products are also being considered. Second, the Drug Enforcement Administration published a final rule that moved all hydrocodone combination products from Schedule 3 to Schedule 2. This action imposes stronger regulatory controls and administrative and civil sanctions on persons, but also has the effect of changing the statutory and guideline penalty structure for offenses involving hydrocodone combination products. The proposed amendment responds to these administrative actions in two ways. First, the proposed amendment deletes references in the guidelines to Schedule III hydrocodone as obsolete. Second, the proposed amendment provides a single marijuana equivalency for hydrocodone offenses, whether single entity or in combination, that is based on the actual weight of the hydrocodone involved rather than the number of pills involved or the weight of an entire pill. Specifically, a marijuana equivalency under which 1 gram of hydrocodone actual equals 6,700 grams of marijuana is proposed. The rescheduling of hydrocodone combination products also raised severity issues, and the proposed amendment addresses those issues by assigning hydrocodone actual the same marijuana equivalency as oxycodone actual. The severity level, 6,700 grams, is based on a 1-to-1 ratio of hydrocodone to oxycodone in marijuana equivalency, which reflects a view that equivalent amounts of hydrocodone and oxycodone cause the same pharmacological effects on the body. A motion to promulgate the proposed amendment with an effective date of November 1st, 2015, and with technical and conforming amendment authority to staff is appropriate at this time.
Is there a motion?
So move.
Is there a second?
Second.
Any discussion? I'll make these comments. Our amendment responds to changes by the DEA and the Food and Drug Administration, DEA, Drug Enforcement Administration. This year, the DEA moved certain pharmaceuticals containing hydrocodone from the less restricted Schedule III to the more restricted Schedule II. At roughly the same time, the FDA approved several new and powerful hydrocodone pharmaceuticals. These changes required the Commission to act. If the Commission took no action at all or simply deleted the entry for Schedule III hydrocodone in the drug equivalency table, all hydrocodone pills would be punished based on the weight of the mixture, which would create serious proportionality issues where offenders with less actual hydrocodone could receive much longer sentences. In order to prevent this disparate outcome, the Commission elected to base the drug quantity on the weight only of the hydrocodone in the pills. The decision to use hydrocodone, the actual hydrocodone, instead of the weight of the whole mixture was supported by public comment from the Department of Justice, the Federal Public Defenders, the Probation Officers Advisory Group, line prosecutors, and practitioners. We were persuaded by testimony and comment that it was appropriate to use actual weight for this pharmaceutical because of the serious proportionality issues otherwise implicated. As you heard, the Commission has adopted a marijuana equivalency for hydrocodone that is equal to the existing equivalency for oxycodone. 1 gram of hydrocodone is equal to 6,700 grams of marijuana. Based on the expert evidence regarding the potency of hydrocodone, its medical uses, and the patterns of abuse and trafficking, we were persuaded this was the appropriate equivalency. Our review of scientific literature and testimony from abuse specialists demonstrated that the potency of hydrocodone among drug-abusing individuals is virtually identical to that of hydrocodone. Further, the DEA and others expressed the view that hydrocodone and oxycodone are very similar to each other with respect to the methods and frequency of their trafficking, and the users of both drugs share similar characteristics. This, along with the enhanced abuse potential for new and powerful hydrocodone pharmaceuticals, convinced us that the drug equivalency we selected is the right policy decision. Now it's time for the vote on the motion. All in favor?
Aye.
Any opposed? The motion's adopted, and let the record reflect that at least 4 commissioners voted in favor of the motion. Economic crime.
Yes, this proposed amendment is a result of the Commission's multi-year study of 2B11 and makes several changes to that guideline. First, the proposed amendment revises the definition of intended loss at 2B11 to mean the pecuniary harm that the defendant purposely sought to inflict. This reflects certain principles discussed in the 10th Circuit's case in United States v. Manitow, in which the court held that intended loss contemplates a loss that the defendant purposely sought to inflict, and that the appropriate standard was one of subjective intent to cause the loss. Such an intent, the court held, may be based on making reasonable inferences about the defendant's mental state from the available facts. Second, the proposed amendment revises the victims table at subsection B2 to incorporate substantial financial hardship as a factor. Specifically, it amends the table so that the two-level enhancement applies if the offense involved 10 or more victims, or mass marketing, or if the offense resulted in substantial financial hardship to one or more victim. The 4-level enhancement applies if the offense resulted in substantial hardship, financial hardship to 5 or more victims, and the 6-level enhancement applies if the offense resulted in substantial financial hardship to 25 or more victims. As a conforming change, the mailbox rule in Note 4C 2 is revised to refer to 10 victims rather than 50. The proposed amendment provides factors for the court to consider in determining whether substantial financial hardship resulted. Because one of these factors is also reflected in the departure provision at Note 20A6, the proposed amendment deletes that factor, substantial harm to a victim's credit record, from the departure provision. The proposed amendment also deletes prong 3 of subsection B16B, relating to an offense that substantially endangered the solvency or financial security of 100 or more victims. Third, the proposed amendment revises the specific offense characteristic for sophisticated means in subsection B10C. The proposed amendment narrows the scope of the specific offense characteristic to cases in which the defendant intentionally engaged in or caused sophisticated means. Fourth, the proposed amendment addresses offenses involving the fraudulent inflation or deflation in the value of a publicly traded security or commodity. The proposed amendment revises the special rule at application note 3F9, which sets forth a method for calculating loss in cases involving securities fraud, and establishes the formula as a rebuttable presumption of the actual loss. Under the proposed amendment, the method provided is no longer a rebuttable presumption. Instead, the special rule provides that the court may use any method that is appropriate and practicable under the circumstances, and provides one such method that the court may consider. A motion to promulgate the proposed amendment with an effective date of November 1st, 2015, and with technical and conforming amendment authority to staff is appropriate at this time.
Is there a motion?
So moved.
A second?
Second.
All right, I think a lot of people want to discuss this one. So why don't I start with the Vice Chair, Judge Breyer?
Thank you. I wanted to comment on two aspects of the proposed amendment, one dealing with loss and the other dealing with fraud on the market. Let me first address the issue of loss. I assume you can hear me? Is that fair to
We
say?
can hear you.
Okay. More than 2 years ago, the Sentencing Commission embarked on a study of the sentencing factors for fraud offenses. In that regard, we held a symposium in New York City, followed by critiques of the present fraud guidelines from judges, practitioners, academics, victims advisory groups, and other interested parties. In particular, the Commission received a thoughtful set of proposals from the American Bar Association study group, comprised of judges and practitioners who had far more experience than Commission members in applying these guidelines. In sum, their comments reflected a view that, among other concerns, the loss table, which drove the length of a sentence, was unfair, unduly punitive, since it was based upon a logarithm scale, and inappropriate as a useful measure of the true harm suffered by victims. The ABA suggested that instead of emphasizing the loss calculation, which drove the length of a sentence, we should instead look to factors reflecting the culpability of the individual defendant in setting the sentence. I, for one, agree with many of their observations. Nevertheless, before embarking on this very difficult task, of assigning levels of punishment to these various factors, the Commission first wanted to determine what judges have actually done in the recent past in these fraud cases. The result of this study, for which I'm quite grateful to the staff of the Sentencing Commission, was extremely informative. As the chair of the Commission, I believe, will point out, that there is a strong correlation between the sentencing guidelines and the sentence actually imposed by judges at the lower levels of law. In fact, this is true in cases in which losses are less than $400,000. However, as the losses increase, so do the disparities between the guidelines and the actual sentence imposed. In fact, once you reach losses of greater than $7 million, and by the way, that's nearly 300 cases, judges follow the guidelines in only 1 out of 4 cases. The conclusion I came to was whatever justification the Commission had for not changing the impact of the loss table at the lower amount, this justification completely fails at the higher level. While 83% of the cases are involve losses less than 400,000, 17% of the cases are greater than this figure. Today, the Commission fails to address this issue, even after a multi-year study. You might ask, so what? Why should we care that judges do not follow the guidelines in 17% of the cases? My answer is that we have a duty to address this problem, not only from the point of view that a significant percentage of cases are not reflective of the anchoring effect of the guidelines, but from the larger concern that we must make guidelines that judges will find lead to reasonable sentences for the offender. Under the Sentencing Reform Act of 1984, we were instructed by Congress to examine sentencing practices, and where these practices substantially vary from the guidelines, we should take action and should consider whether we should amend those guidelines so that they become relevant to federal judges. My colleagues have suggested in our frank discussions over the past several months that they will address this problem sometime in the future. I believe we should have addressed it today. We have studied this issue for nearly 4 years, and I think that now is the time to act. Thank you.
Thank you. Who else would like to?
Thank you. As Judge Breyer noted, for the past 2 years, we've been studying the question of what amendments are needed to the fraud guidelines. We received many helpful comments and statements at hearings that have pointed out that the guidelines disproportionately focus on loss amounts and do not sufficiently distinguish among defendants of differing levels of culpability. Also, as Judge Breyer noted, the ABA in particular suggested a framework for us where less weight would be placed on loss and more work would be done by various culpability factors that they identified in comments to us. I agree with the ABA's diagnosis of what is wrong with the fraud guidelines and also its focus on a solution that's targeted toward culpability. But the problem of insufficient attention to culpability is not unique to fraud. It is widespread throughout the guidelines manual, and in fact, goes to the very core of the guidelines approach. The guidelines place an emphasis on objective factors of harm without paying much attention to the defendant's culpability with respect to that harm. The guidelines do not draw distinctions between defendants whose very purpose is to achieve that harm and those who never intended or even foresaw that harm. The unlucky are placed in the same grid as the malevolent. The question is how to fix this fundamental problem that transcends fraud and permeates the book. Today, we took a step in that direction by expanding when mitigating role should apply. This is the provision in the guidelines tasked with doing much of the so-called culpability work. The guidelines essentially assume that offenders intend all the harm caused and set offense levels on that basis. The mitigating role provisions provide carve-outs for those of lesser culpability. It's designed for those who play lesser roles in offenses or who do not plan or make decisions about the way the crime will be committed. It is for the hired hands who do not share in the profits. Unfortunately, as Chief Judge Saris mentioned, judges do not seem to be paying much attention to this provision. It's unclear why judges are not using it, but today we're taking steps to increase its use. We've emphasized that a defendant can receive a mitigating role adjustment even if he or she performs an essential or indispensable role in the criminal activity. If he or she is less culpable than the average participant in the criminal activity, mitigating role applies, whether the defendant's role was essential or not. We've also provided a non-exhaustive list of factors for judges to identify those who should receive this adjustment. Some of these are particularly relevant to the fraud cases and echo the culpability factors identified by the ABA, including taking into account the extent to which the defendant stood to benefit from the criminal activity. I'm pleased we've taken these steps, but I believe we need to go further. Mitigating role provides a reduction of at most 2 to 4 levels. That means mitigating role does more, proportionately speaking, for lower level rather than higher level offenses. In areas like drug and fraud offenses, where quantity and loss can quickly get you to high offense levels, that means that the fortuity of quantity and loss are doing significantly more work than the much more relevant question of a defendant's culpability and relative role. Particularly for those fraud offenders with high loss amounts, mitigating role is not enough to achieve punishment proportionate to culpability. As a result, I think we need to set as a future priority a mitigating role cap in fraud cases and to think seriously about whether the 2 to 4 level reduction framework makes sense or whether it needs modification and expansion. More fundamentally, I think we need to expand how the guidelines account for culpability for all offenders. Mitigating role focuses on just that, role, but it doesn't pay sufficient attention to a defendant's mens rea with respect to the harm factors identified by the guidelines. Mens rea is a bedrock principle of criminal law for a reason, and its absence from the guidelines is, in my view, a mistake. In that vein, I regret that the Commission was not able to agree this amendment cycle to change our rules on jointly undertaken criminal activity to require that defendants intend a co-participant's criminal activity. Currently, the guidelines hold defendants responsible for the actions of others under a negligence standard of reasonable foreseeability that imposes liability even on those defendants who honestly had no idea the co-participant would engage in that conduct. Negligence standards are rare in criminal law because the entire point of criminal law is to punish those who deserve it because of culpable choices. It draws a line between culpable conduct and conduct that accidentally produces harm. Throughout American history and in the common law, negligence standards have been reserved for only the most serious harms, such as conduct that results in death. The guidelines, in contrast, use negligence as an animating principle of relevant conduct and in general, and as a result, it produces guideline sentences that are not proportionate to culpability. Judges, in contrast, I believe are attuned to notions of culpability, and in a post-Booker world, I believe they are accounting for them. I think the guidelines should reflect this as well, and I hope we can continue to do more work on this fundamental issue as we move forward and continue to consider what the guidelines should look like now that we are in an advisory world. Thanks.
Thank you. Commissioner Friedrich?
I want to thank the many stakeholders who've commented on the proposed fraud amendments. The thorough and thoughtful comments have helped us, have been extraordinarily helpful to us in our deliberations. While the amendments the Commission adopts today do not change the structure of the fraud guidelines significantly, I'm hopeful that the Commission will consider broader changes in the future as part of a larger scale project to reform the existing advisory guideline system. More than 10 years have passed since the Booker decision, and yet we continue to operate under a guideline scheme that was designed to be mandatory. Among the most complex of the guidelines is the fraud guideline, with its 2 separate base offense levels, 19 specific offender characteristics, 4 cross-references, and 18 pages of application notes. Courts must routinely engage in complicated sentencing calculations to arrive at a correct starting point under the guidelines, only to set the sentencing range aside and exercise their broad discretion to vary outside of this range pursuant to Booker and 18 U.S.C. 3553A. Under the current system, such variances, though common, are subject to little, if any, substantive appellate review. And contrary to the Supreme Court's prediction in Booker, it is quite clear that appellate review for reasonableness has done little to iron out the sentencing differences among courts. The Commission's study of post-Booker case law and data reveals ever-increasing and unwarranted disparities across the country, regions, districts, and even within courthouses. I strongly believe that the time has come for the Commission to work hand-in-hand with Congress to reform the current advisory system to make it a binding or a presumptive system. To satisfy the constitutional requirements of Booker and to better achieve the goals of the Sentencing Reform Act, the Commission should first simplify the guidelines, particularly the fraud guideline. The Commission should also seek statutory changes that would require prosecutors to prove beyond a reasonable doubt to a jury any aggravating factor that is not admitted by a defendant and which would increase a defendant's sentencing range. Finally, the Commission should appropriately and fairly cabin departures or variances from that range and couple this limited authority with meaningful appellate review. Under such a system, the fraud guideline would be dramatically simplified, with fewer loss categories and many fewer specific offender characteristics. Such across-the-board structural reforms would also invite the Commission to revisit the role of relevant conduct in the fraud and other guidelines, yet another important issue for which we make no substantive changes today. These proposed reforms are significant ones that will require careful study and deliberation by the Commission and other stakeholders. But I continue to believe, as others before me have eloquently advocated, that such structural reforms will best further the important goals of the Sentencing Reform Act.
Thank you. Commissioner Pryor.
I too want to thank all those who commented on and participated in our deliberations about reforming the economic crimes guideline. Our vote today to make modest changes to the guideline for economic crimes should not be understood to mean that we are all happy about the current operation of that guideline or about the general condition of the federal sentencing system. I, for one, am not. I am convinced that our guidelines manual, which was designed for a mandatory system, is unsustainable in our post-Booker world. 10 years ago, the Supreme Court decided United States versus Booker, and soon afterward, it became apparent that the current guidelines manual could not work in an advisory system. 5 years after the Booker decision, Commissioner Wroblewski sent the Commission the annual report of the Department of Justice on the operation of the sentencing guidelines. What he wrote was true then and is even truer today. He explained that the data compiled by the Commission shows that, quote, federal sentencing practice is fragmenting into at least two distinct and very different sentencing regimes. On the one hand, there is the federal sentencing regime that remains closely tied to the sentencing guidelines. On the other hand, there is a second regime that has largely lost its moorings to the sentencing guidelines. The department explained three problems with what it called this evolution of federal sentencing into two different regimes. First, it leads to unwarranted disparities. Second, these dichotomous regimes will over time breed disrespect for the federal courts. Third, although certainty in sentencing is critical to reducing crime rates further and deterring future criminal conduct, the current trends are toward less certainty. In my view, the time has come for the Commission to undertake a comprehensive review of the operation of the guidelines and to begin a discussion with Congress and the public about how to simplify the guidelines and make them effective in a post-Booker world where the government has to prove any aggravating fact to a jury beyond a reasonable doubt.
Thank you. Yes. Commissioner Wroblewski.
Thank you, Judge Saris. I'll be brief. I mostly want to first at least thank my colleagues on the Commission for all the work that the Commission has done in this amendment cycle, and especially for the consideration of the views of the Department of Justice. I think the consideration of the economic crimes issue is an example of the thoughtful and thorough consideration that the Commission has given to all the amendments. As has been referenced, the Commission held a symposium. It has collected and analyzed data. It has held multiple hearings. It has provided notice of proposed amendments. It has received hundreds of pages of comments, and I have been present for very thoughtful and serious consideration and deliberation among the commissioners. I think this thorough and thoughtful approach is the Commission at its best, and I appreciate all the work that's been done. I also want to join my colleagues in thanking first the staff for all of its work in both putting together things like the symposium, all the data analysis, and all the work that the staff has done. It's been tremendous work. And I also want to join the Commission in thanking the stakeholders for all of the input that we have received. I was particularly honored to be a small part of the ABA working group. And I know among some of my colleagues and some in that ABA group there is some frustration. But I think, as can be heard from some of the comments of my colleagues, the ABA work has had a significant impact on our thinking, and I think potentially will have significant impact on the Commission's actions into the future. The ABA product addressed the structure of the guidelines, issues of culpability, complexity, the role of the guidelines, the role of the sentencing judge, the role of the prosecutor, and all of these larger structural issues, I think, will be considered by the Commission in the years ahead. I am very much looking forward to those discussions. And again, thank you, Judge Saris, and all of my colleagues for all the work over the course of this amendment year.
All right, thank you. As you can hear, there have been a broad range of views on many of the complex issues raised by the economic fraud guidelines. We began our review in earnest in 2010 in New York City when we heard from stakeholders, some stakeholders, that the economic fraud guideline was too high, that it produced unreasonable sentences, and that it was fundamentally broken. At the same time, the Commission was hearing in a survey of federal district judges that the vast majority, that is 90% or so, thought the fraud guidelines were either just about right or too low. We struggled with excellent work of staff and everyone on the Commission to interpret these seemingly contradictory results. What we found was that in most cases the fraud guideline provided an anchoring effect, but that there were opportunities for targeted changes we could agree on. Accordingly, our amendments shift the current focus of the fraud guideline while maintaining the core principles that have formed the basis of sentencing these offenses since the guideline's creation. These targeted changes respond to concerns raised by commissioners, judges, and other commenters, particularly as have had the others have done. I'd like to thank the American Bar Association for the thoughtful work in this area. In particular, the amendments respond to comments that the guideline should better address qualitative harms to victims and appropriately assess defendant culpability, while also recognizing some concerns regarding double counting of the victim enhancements and the loss table. Our changes to the victim enhancement are intended to address concerns raised by our Victims Advisory Group, and I thank them as well, and others that the existing guideline overemphasizes the number of victims to the detriment of qualitative harms, in other words, quantity over quality of the harm, and that a smaller number of victims may suffer. Today, we voted to include a victim enhancement if even one victim suffers a substantial financial harm. However, we also eliminated 4 and 6 level enhancements based only on the number of victims without looking at the quality of the harm. We also shifted the focus to the offender's individual culpability in a variety of ways to ensure that when the court is calculating intended loss, that only amounts the defendant purposely sought to inflict or counted, and that the enhancement for sophisticated means addresses only the defendant's own conduct. We also amended the mitigating role guideline to encourage reductions for low-level fraud offenders who played minor roles, such as those with no proprietary interest in the criminal activity. Finally, we caution that there are very few cases at the high end of the loss table. That was the data that we collected. 64 in the top 4 levels involving over $50 million, and only 14 in the top 2 levels in fiscal year 2014 involving over $200 million. Many judges and stakeholders have voiced concerns as well about fraud on the market offenses. But when we looked into them, there were only 7 fraud on the market cases in 2012 and 2013. Thus, these very high loss levels are rarely reached, but we acknowledge that they can result in tremendously contentious and costly litigation. We hope that the shift to a greater emphasis on individual culpability will make these sentences more proportionate and fairer. We believe that this slate of fraud guideline amendments, taken together with other amendments on mitigating role, allows the guidelines the needed flexibility to differentiate among fraud offenders based on culpability and harm, while ensuring appropriate punishments for the most serious offenders. I think we've heard from everybody. Any last thoughts? Maybe I shouldn't ask.
I would like if you could comment on the fraud on the market measurement.
Okay.
Because I think that's a separate issue. On the issue of measuring loss in fraud on the market cases involving publicly traded securities, the Commission has agreed today to strike the rebuttable presumption that a market approach should be utilized for the measurement of loss. As a judge who has attempted to use this market approach suggested by the Commission, I have found it to be unworkable in cases in which the security retains more than a nominal value. Indeed, there is no evidence that courts can successfully use this approach, especially in light of the Supreme Court's unanimous decision in Dura Pharmaceuticals that many factors must be considered before arriving at a true measurement of loss. While Dura Pharmaceuticals address civil liability, when judges send people to jail for a sentence, the length of which is set by a measurement of loss, I suggest that to utilize this method will only result in a battle of the experts, leading to an empirically inaccurate measurement. So I hope that our failure to remove this flawed and cumbersome method is not viewed by judges as an invitation to conduct lengthy evidentiary hearings which give the pretext of exactitude. Indeed, in my view, it should only be used in cases in which it will result in a reasonable and accurate measurement of loss. I, for one, do not believe that that will ever be the case in instances in which the price of securities are affected by numerous market forces. Thank you.
Thank you. Time for the vote. All in favor of the motion?
Aye.
Aye.
Any nays? The motion is adopted, and let the record reflect that at least 4 commissioners voted in favor of the motion. Now, in January, the Commission voted to publish an issue for comment, seeking public comment on offenses in which controlled substances are colored, packaged, or flavored in ways that appear to be designed to attract use by children. Today, we have not voted to promulgate an amendment addressing this issue. Several of my fellow and sister commissioners wish to make comments concerning the matter, and Vice Chair Breyer, I start with you.
Thank you, Judge Saris. The Commission today has failed to take action on a proposal to enhance penalties for drug offenders who flavor or market a controlled substance with the intent of enticing children to purchase these drugs. I strongly disagree with those commissioners who hold the view that such an enhancement is not warranted. I believe that the record demonstrates otherwise. First, the Commission has received comments endorsing such a proposal from many sources. In particular, I would note that a bipartisan effort led by Senators Grassley and Feinstein have urged the Commission to act. This is not a recent position of these senators, nor of the Senate as a whole. To the contrary, proposed legislation was adopted by a unanimous Senate in 2010 and has once again been introduced before the Senate today. Second, Senators Grassley and Feinstein have cited more than 30 examples of incidences involving flavored drugs. While these cases are not pending in federal court, they nonetheless reflect the concern that with states legalizing certain controlled substances, it is essential at the same time to ensure that these drugs are not marketed to children. Finally, numerous law enforcement agencies and organizations have called for increased penalties. I regret that we have yet to act in this matter, and I assume that Congress will direct us to take action in the near future. Thank you.
Thank you. Commissioner Barco?
Thanks. I want to thank Senators Grassley, Feinstein, and the many law enforcement organizations for submitting comments to draw our attention to the issue of candied or flavored drugs. As these commentators rightly point out, anyone who flavors drugs with the intent to appeal to children should receive a higher punishment. All the members of the commission agree with that, and we are all thankful that law enforcement alerted us to this issue. The question is about whether we are in a position to take action on this issue right now. It's my view that on the record we have before us, it would be premature to take any action. Our excellent staff combed our records and also reached out to the DEA and the Probation Office's advisory group, and we could not identify a single federal case where a defendant intentionally marketed or distributed flavored or candied drugs to children. In the absence of any cases, the Department of Justice asked us to proceed cautiously. The department told us that it's not certain whether this problem, should it arise, would best be addressed with a mandatory vulnerable victim enhancement or through a provision that targets deceptive packaging. The question of packaging is complicated by the fact that Washington and Colorado have legalized the sale of marijuana, and those states are currently addressing how best to make sure that marijuana products are appropriately labeled so that they do not end up in the hands of children. Without a single federal case on this issue, the Commission would be setting policy based on guesswork, not on data or real-world experience, and it would be doing so against the backdrop of serious federalism issues raised by Colorado and Washington's regulation of marijuana sales. I do not believe it's appropriate for the Commission to amend the guidelines under these circumstances. Instead, I believe the sound course is for us to continue to monitor and study this issue closely and to take action once we have the appropriate record to evaluate what to do. Thanks.
Thank you.
I'd just like to add that I share Commissioner Barco's concerns, and I do think this is an area we should continue to monitor in the future.
Thank you.
I too agree with Commissioner Barco.
Thank you. Thank you. So at this point, what we're going to be doing is ask the General Counsel if there are any remaining matters for the Commission's consideration.
Yes, Judge, there's one remaining matter. In light of the fact that several of the amendments that you have just voted on to promulgate may have the effect of reducing the guideline range for a category of offense or offenders, specifically the single sentence rule, the inflationary adjustments, hydrocodone, and economic crime, is there, pursuant to Rule 2.2 of the Commission's Rules of Practice and Procedure, a motion to instruct the staff to prepare a retroactivity impact analysis for those amendments? Is there such a motion?
Is anyone moving? No one's moving. So I want to make a brief comment about that. Whenever the Commission promulgates an amendment that lowers penalties, it has a statutory obligation to consider whether to make such amendments retroactive. This is an obligation that the Commission does not take lightly. In making the determination, we consider, among other things, the purpose of the amendment, the magnitude of the change in the guideline range made by the amendment, and the difficulty of applying the amendment retroactively. These factors did not weigh in favor of making the single sentence rule, the inflationary adjustments, and the economic crime amendments retroactive. I do want to flag one issue, though. Today, the Commission voted to use a hydrocodone actual weight standard in calculating drug quantity, but did not ask staff to conduct a retroactivity impact analysis for that amendment. This is a departure from what we did with the oxycodone in 2003, and I want to explain why a retroactivity impact analysis was not necessary. The Commission staff has already reviewed all the hydrocodone drug trafficking cases sentenced after October 6, 2014, when the DEA rescheduled the drug to Schedule II and did not identify any offenders who would receive a lower guideline range if the amendment that we voted on today were made retroactive. For this reason, no retroactivity impact analysis is necessary for hydrocodone. Is there any other business before the commission? Hearing none, is there a motion to adjourn?
So moved.
Is there a second?
Second.
All in favor?
Aye.
Any noes? All right, so we're now adjourned. Thank you very much.
Thank you.